Hello, everybody. I'd like to begin by acknowledging the traditional owners and custodians of the land on which we meet today, Mianjin. And I'd like to emphasize that this land was never ceded, but rather taken. On behalf of everyone here and the institution for which I work, the University of Queensland, I would like to pay respect to the Turrbal and Jugara peoples, their ancestors and their descendants, and their enduring cultural and spiritual connections to country. We stand with them in solidarity and acknowledge the complicity of institutions like the university in ongoing processes of dispossession. I'd also like to extend that collective acknowledgement and solidarity to the traditional owners and custodians of the various lands from which you and our speaker join us today. Welcome to the final lecture in the 2024 People, Plants and the Law online lecture series. One of the aims of the series is to bring together personal historical reflections from a group of the most important figures working on people, plants, and the law over the last 40 years. Another aim is to showcase some of the best work currently happening in the area. We've been running for 3 years now, and you can find recordings of previous year's lectures, along with recordings of all of this year's lectures on the series website. If you have any questions for our speaker, please post them in the comments section and we'll do our best to get to some of them after the talk. In today's lecture, we're once again showcasing some of the most exciting work currently being undertaken, but this time, once again, from one of the longest standing legal scholars working on people, plants, and the law. Our speaker today is Chair of Global Intellectual Property Law and the Director of the Queen Mary Intellectual Property Research Institute at the Centre for Commercial Law Studies, Queen Mary University, London. Professor Suthersanen, LLB, LLM, FRSA, is the author of a number of definitive works, including a recent second edition of Duffield and Suthersanen on global intellectual property law. She is also currently working on a monograph on copyright and public interest, comparative and historical analyses. Her work has been used and cited by the European Commission, the OECD, UNCTAD, WIPO, WTO, and the Australian and Indian governments. And she has served as a consultant and given evidence to international and regional bodies, including WIPO, UNESCO, UNCTAD, the European Parliament, the European Commission, and the governments of Israel and Singapore. More recently, she was invited to sit as a WIPO expert on the Ad Hoc Committee on Traditional Knowledge and Traditional Cultural Expressions in February 2023. It's a great pleasure to hand over to Professor Suthersanen, who will be drawing on this wealth of experience and speaking today on WIPO Treaty on TKGR 2024, constructing guidelines for disclosure and ADS. Thank you so much.
Thank you, Beres, for that very generous introduction, and thank you also for inviting me to the series. And I'm slightly awed because I'm not sure I would call myself an expert who has been working in the field of people's plans for a long time. And I was, shall I use the word, dragged into it by my co-author, Graham Dutfield, who has been working in this area. And as I often do say, well, at some point you may need a black letter, boring lawyer sitting next to you who gets very excited by legal provisions. And that is really the background I'm coming into this paper. And the paper isn't actually finalized yet. It's perhaps the first part of the more macro discussion analysis of the WIPO Treaty in relation to the disclosure provision. And the next part, which I hope to do next year, is to be a bit more granular as to the different procedures and implications of different types of provisions in national laws. So to start with, as everyone knows, we've had, okay, I'm going to see. Okay. We've had the WIPO treaty that came out earlier this year, and part of that treaty revealed a new international norm. And this paper is trying to argue that this particular international norm, which usually sits as far as, you know, intellectual property lawyers, as opposed to just patent lawyers, someone who's always been involved in traditional knowledge in this area, it usually sits in a more procedural area in relation to patent applications. And I am trying to argue here that this new international norm should really be viewed as a far more bigger implication in relation to patent law. Now, the article I'm going to talk about is Article 3 of the treaty, which of course hasn't really come into force. It requires 30 signatories. I believe Nairobi, but I may be wrong, signed it about 2 weeks ago. And so we're waiting for more signatures and ratifications rather than signatures. The disclosure requirement in Article 3 has two different parts to it. One of it is Article 3, and the other of it is Article 5, which talks about sanctions and remedies in cases of non-disclosure. And the treaty itself talks about disclosure in relation to patent applications based on genetic resources. So that's one area of uncertainty, and I will maintain right throughout the paper and the whole article when finished that the notion of based on genetic resources is vague, but it's going to remain vague, and there's no way to unvague it, frankly, because it will depend on substantiality. However, where you have a patent application based or incorporating genetic resources, the treaty has some mandatory requirements, i.e. applicants have to disclose the country of origin. If you don't know the country, then the source of genetic resources. And that really pertains to where genetic resources are in situ in countries and where you can identify very clearly that you have got it from, let's say, Mauritania. Or in the second part, secondary sources, where if the genetic resource has drifted, migrated to a database in a research center or in a seed bank, etc., well, then one has to disclose the source, if known. And that is part of the entire grundnorm of the two articles, is there is a supposition that if it's known, yeah. And where the genetic resource is associated with traditional knowledge, then one has to identify either the indigenous peoples or the local community. If not known, then the source. Again, that's a secondary sources. For example, and it's stated in the treaty, and a lot of the drafts, it's clear. You may know the traditional knowledge emanating from a publication, let's say, or perhaps hearsay, or perhaps some documentation where it has become, as is quite often the case, detached from the country of origin and detached from the indigenous persons and reattached to several countries and several indigenous persons. And there has been one or two very good articles detailing the sort of network of information that circulates globally in relation to genetic resources and then the traditional knowledge associated with it, which highlights the fact that a lot of it has been detached, and you have to think of implementing these disclosure requirements knowing there has been detachment. Which goes to, you know, the final part of this paper. What is the point of the disclosure requirement, or what is the justification? Where the patentee has no idea where it's coming from, they have to affirm that to the best knowledge, everything they have stated in the application is true and correct. Contracting parties and member states can give guidance as how to not to do it. I think Article 3.5 is really important, partly because as we look at the history very briefly, one of the rationales for imposing an international rule of law on disclosure was to shift the burden from origin countries or origin communities and peoples from chasing and tracking the usage of resources or knowledge all over the world, and to try and shift that burden of proof to countries that were actually vesting patent rights outside their sovereignty. And yet this treaty says quite clearly it's not going to place an obligation on officers, national officers, granting the patent to verify the authenticity of the disclosure. In other words, I can just go around and get a patent, perhaps, I don't know, and say, well, I don't know where it comes from. It's too difficult to find out. Article 5, which is in my mind very much linked, is what happens if you don't disclose it rightly. You certify and say it's true and correct to the best of our knowledge. It sort of states that states are given flexibility to place appropriate, effective, and proportionate legal, administrative policy measures to address a failure. However, you need to give the patentee a right to rectify the failure, shall provide an opportunity to rectify a failure. And then you read it in concordance with Article 5.3. Member states are not allowed to use the treaty to revoke, invalidate, or render unenforceable a patent right just solely on the basis that the applicant failed to disclose the information specified in Article 3. And the two versions of the article, of course, went through several drafts. And if one looks at the draft versions, which, although in the written paper, I'm not going to talk about it now because there are so many draft versions. But some versions had notions of public interest incorporated into the language of the treaty, which in the final run-up during the diplomatic conference, it was watered down. Much of it was watered down. And it is actually very understandable, having sat through one of the IGCs and also the expert committee, and then finally following the whole diplomatic conference. It was understandable. And having spoken also to the Director General of the section, Van Venlen, treaties are compromises. We all know treaties are compromises. And at some point, that there is this balancing feature involved as to what has to come out in order for the rest to go on. And I believe Article 5 just shows you the compromises taken. In relation to assuage, I don't have to say, perhaps, the major countries involved, which were very reluctant as to previous versions. I mean, it includes the United Kingdom, which is strange, because usually we don't really have such strong views, but they did have strong views during the IGC, I do recall. The European Union and the United States. So this is the compromise between you shall put in place measures, however, you need to give them a chance to rectify, and however, you can't invalidate, revoke, or render unenforceable just because they failed to disclose. You can provide post-grant sanctions or remedy where there has been fraudulent intent. Now, the notion of fraudulent conduct and intent, I'm going to come back to in Article 5.2 and 5.4 because it's relevant, I believe, in how to fix the problem. Of course, you can all say to me, the problem is in your head, Uma, because nobody else can see it, but I do see the problem. So just to give a very quick overview as to how the disclosure requirement came up in the 2024 treaty, the whole discussion, of course, started long ago. And you know, it very much started with the African nations, you know, from the 70s and 80s when they're talking about it. But I'm going to make my, I need to shift this thing, you can't see the top. In terms of making it an international rule, you can trace it back much further, but I've just decided to start with the 2002 World Summit on Sustainable Development. And again, one is talking about a WIPO treaty on intellectual property. But underpinning it, of course, is that linkage to development and the linkage to the CBD and biodiversity. So when you start with the 2002 World Summit, you see a beautiful, huge, big plan, but it also a plan that spread across several international platforms, you know, through the Bonn guidelines. There was the CBD that was coming up, and then you have an international regime under the Convention on Biological Diversity as to access to genetic resources, especially those in situ in countries. The implication being that such countries were developing countries or countries in what is usually badly termed the South, and that access should be related to any benefits accruing from such access, and where you use genetic resources, and then at some point it becomes associated TK to get patent grants and benefits thereof. So you have the whole access and benefit sharing scheme coming in. Then the WIPO IGC is also concurrently going on in relation to whether or not indigenous peoples and local communities should get rights in their knowledge processes and workings. And several platforms and laws coming out with we should all share technology. And this notion of technology sharing, of course, is really old. Very old. I remember in my undergraduate days in National University of Singapore doing a dissertation on the UNCTAD Transfer Technology Code many, many moons ago. I'm not going to say how old I am, but really a long time ago. And you know, it's in most treaties and most discussion that there should be sharing. And I believe this new 2024 treaty does go in some way as to implement what, you know, is rightly said, a practical and efficient way of ensuring access and benefit and sharing of technologies, i.e. a disclosure requirement. What is interesting as well is the cross-platform between the COP Secretariat in relation to the CBD, the WTO, you know, ministerial declarations and the WTO platform, and of course WIPO. And what is really nice to see is all these commitments were embedded in 2003 by the United Nations General Assembly, endorsing the entire plan. And throughout this whole discussion, there is a disclosure requirement always coming up. Some authors and reports have stated, and it was interesting looking at discussions in this period, you know, late 1990, early 2000s, saying that the failure of international law to incorporate the disclosure rule, which was such a simple rule, was because of the cross-cutting platform discussion and that the agenda was getting lost. That's one interpretation, and indeed, there's a paper by I believe, but I could by Josh Sarnoff and Carlos Correa, who very much argued that the correct platform was WTO and TRIPS, as we will see, for the suggested amendments to the TRIPS agreement, rather than WIPO, which was far too narrow. Yeah. So from the cross-platform discussions, we get lots of versions of what should be done. For example, the WIPO patent law treaty at the bottom does have a disclosure requirement in relation to, substantive patent law requirements. And this has always been available under national laws, i.e. that you should have adequate disclosure and sufficiency in order to work the invention. And as part of traditional patent law, with that necessarily incorporating language from CBD or discourse, all the discourses on traditional knowledge and access to benefit sharing. The CBD has its variations, as many of you know, from Articles 8J, 15, and 16. In relation to ABS and transfer technology. The Nagoya Protocol as well talks about we really need to have something in order to monitor the source of the genetic resource. And your general articles in the TRIPS agreement, Article 29 is the general disclosure requirement in patent law. I put that Article 22 because I've read 2 papers with a really interesting, but I'm not convinced, really interesting argument that one could also state that there is international rules on disclosure of origin where you are incorporating resources from a geographical area. And Article 22 is about geographical indications of origins. And these 2 articles I read argue that you can use GIs really, where the product is the product invention is stated to use certain things coming from a geographical indication, and yet it's not disclosed. That is a deception to the public, and the GI notion of the public in TRIPS it was argued should be wide enough to include patent office officials as well as other competitors and those who read patent specifications. Arguable, but not that convincing, I think. So for all these various reiterations of what should be done in relation to recognizing and respecting the sovereignty of genetic resources where it's in situ, or recognizing and respecting that these resources can travel, but nevertheless there should be some sort of commensurate sharing with our benefits, including technology and respect, of course, and recognition of any traditional knowledge that is associated with the usage of the resources and in various ways. And none of it is very possible unless you have the country of origin of any resources doing constant monitoring of patent grants throughout the world, not only constant monitoring, which perhaps can be quite easily done nowadays if you have access, of course, to the very expensive patent databases and you do text searches. Assuming everything is by text search, is available by text searches. There are some instances when disclosures merely incorporate a photograph or a scanned image of a certificate or the contract where genetic resource is obtained, and that apparently does not come out with text searches, text and data mining searches. It also assumes that origin countries and especially origin peoples and communities have resources to chase patent grants all over the world and in order to challenge them on validity, and this is just not possible. So disclosure was the panacea for so many different calls in so many different platforms and so many different international instruments. And one thing that I did come across, and thank you, my co-author Graham Duffield, for pointing it out to me long ago, in a place far away in 2001 in Kuala Lumpur, the Doha WTO Ministerial Declaration did provide the linkage, which I did wonder about, between TRIPS and CBD. Of course, we all knew about it in discourses, but was there a legal basis for the linkage? You know, what was the provenance of it? And there was paragraph 19 in the ministerial declaration, which did that link. Basically that the TRIPS Council, in relation to the review of under Article 27.3b of the TRIPS agreement, will also include in that review the relationship between TRIPS and the CBD and the protection of TK and folklore and, you know, other new developments. What I was particularly excited by was that the fact that the council was instructed to review and examine, you know, the work in relation to this area by being guided by Articles 7 and 8, and also taking into account the development dimension. And this is also within the TRIPS agreement, that at all points, the TRIPS agreement can be opened up to, and reviewed to take into account the development dimensions. And to a lawyer and to someone, like I said, belatedly came into this area, I think in 2019 or 2018, I published together at Graham Duffield a look at the whole area of traditional knowledge and the ABS guidelines, especially under, you know, Annex 1 of the Nagoya Protocols, arguing that the only way you can have a meaningful implementation of those provisions in the annex is to link it to human rights and interpret it from a human rights angle. I know there are many who do not appreciate the incorporation of international human rights language and human rights norms into this discussion. And the big the most foremost argument is this just makes it very wishy-washy, the boundaries are not clear, etc. But again, as I said, I'm coming from a black letter lawyer approach. Nothing in law is certain. Absolutely not. And in fact, I often wonder at experts in patent law who are angst about the uncertainty of, for example, how do you connect genetic resources and the patent application, the substance, and how does one navigate inventive step, and then how does one navigate the application of Article 7 and 8 of the TRIPS agreement, as you know, its aims and objectives within something as clear as patent law. And I'm always amazed because I have to do quite primarily in copyright law, and you know, guys, we're dealing with an international copyright law which doesn't even have one single statement on when is a work original. The word original doesn't even appear in the international norms, and yet we navigate. So the idea that, you know, human rights dimension adds something, you know, vague to it is part and parcel of the space given by all principles of law, which is a space to be welcomed, I think. And going next to you know, where else has disclosure come up prior to the 2024 treaty? You also see it, for example, in the 2004 COP7 forum, where they did do a decision as to, okay, how do we implement, or how do we get this regime? And we have all the texts, you know, on access to genetic resources, a beneficiary, but we can't get these ABS provisions going. So in that particular COP7 decision, they identified several difficulties and said this must be sorted before we can get to a meaningful implementation of the CBD in national laws. And of course, one of the most important things is disclosure of origin or source, or the legal provenance of genetic resources and associated TK. And just to say, origin, source, or legal provenance, those alternative wordings, basically refers to primary sources, in situ resources within the country, sources like database, etc., or legal provenance will also refer to certificates of compliance, which some countries operate, whereby you go and access the GR and you get a certificate or a contract stating that there has been a negotiated contract with a group of persons, which includes national provisions on prior informed consent, etc. So disclosure in relation to where it comes from and how you got it can include a variety of documents if implemented. The next thing, of course, is there is an attempt to negotiate this into the TRIPS agreement. So you have the draft Article 29 bis coming out to see whether this can be incorporated into the TRIPS agreement, which is, of course, always thought to be the better forum because of membership of WTO as opposed to WIPO. And much of what you read in Article 29 bis in relation to Article 29 bis 2, the draft, you can see some versions of it when you look at the current treaty, i.e., if there's utilization of GR and TK, you need to disclose, primary or secondary sources, or as I was talking about, the certificate of compliance, just to show that there is legal provenance in any such way, or you're going to tell everyone where you got it from. And it should also be compliant with what national laws have. So the next area that one becomes quite intrigued about is, well, which countries already have things inside their laws in relation to disclosure? And more interestingly, which is why I say part 2, is to try and do a far more granular search, looking at whether there have been oppositions under national patent laws. Far more interesting was to see whether the CBD mechanisms were incorporated in a standalone, CBD type sui generis law. Was it incorporated into patent law? And was it also incorporating external penalties, for example, contractual, as opposed to a disclosure requirement? The notion of a contractual requirement where countries say, state in the law that you need certificates of compliance, you need to show the contract whereby you accessed, resourced this particular plant, organism, etc., or you accessed, used the TK associated with it, and there is a contractual evidence of it. This particular contractual route was very much pushed by the United States in the beginning, leading up to the diplomatic conference, that we don't need to change patent laws. We don't need this particular international rule putting a substantive provision into patent laws, because we could use contractual mechanisms. The contrary view is it's difficult. It's difficult because it rather really relies on the implementation of ABS provisions in the national laws. And countries which had ABS type provisions talking about provenance and disclosure, etc., tend to be countries of origin. In the majority, there are other countries as well with disclosure provisions, but unrelated to TKGR. So the interesting thing is what triggers this disclosure requirement. Why do you have to disclose you got something from an origin country or from the origin community or peoples? Is other definitions of what genetic resource and associated TKGR is, and the types of disclosure. Is it just a suggestion? Is it a mandatory disclosure? How do you prove the disclosure, or how do you prove your acquisition of the resources or knowledge, and are there any consequences? And there are a lot of countries, and as I said, part 2, which I'm starting to do, is the granular, looking into country by country or region by region. as in the case of the EU and the Andean community. I mean, the Andean community has a decision number 391, which says signatories of the Andean community do have to state that there should be some disclosure. And the Andean community is one of the few countries that do talk about the access contract, and that you have to supply a copy of the contract to show that all the requisite or prerequisite grants have been fulfilled, that the consents, the prior and forethought consent from the people of the community has been fulfilled. And also perhaps, as in some countries, you'll see there is a pre-patent notion that you have to get certification or affirmation from the national plant office or national seed office or the national authority, designated authority for conservation of biological diversity. So it just that pre-patent office authority differs according to countries, but it's a two-stage process. The first one, the confirmation certificate, which may or may not include a contract, and in this case, in the Andean committee, they assume there should be a contract, and then to also acknowledge it in the patent disclosure. And there are consequences. The consequences is the patent granting office does not have to acknowledge the rights over any of the genetic resources, any byproducts, synthesized products, and associated intangible components, which are in contravention of this rule. Ooh, that's I would agree that that actually can be quite difficult to see. I mean, I understand genetic resources, byproducts, but once you get to associated intangible components, this seems to be a very wide class of IP related goods that will basically have its rights nullified and unacknowledged. If you look at other countries, for example, Belgium has a sort of disclosure requirement already of a statement of geographical origin of biological material, etc., where such origin is known. And Switzerland has a similar one. Yes, the next stage will include a database for the EU member states. They emanate primarily from the EU directive and the EU regulation on protection of biotech inventions and the regulation on ABS of GRTK. In the sense of the EU, I don't know, because me and my co-author have a slight disagreement whether the EU is suggesting that you should disclose or whether they are mandating that one has to disclose the geographical origin of resources. And I suppose at the end of the day, one can say that whether the EU law suggests or mandates disclosure, there is no prejudice to the processing of the application or the validity of the rights. So in one sense, it's one of those things I'm complaining about in relation to the treaty, whether you take it as mandatory. Well, I think in the treaty it is mandatory because of the usage of the word shall rather than may. But even if it's mandatory, if there isn't a sufficient sanction for non-disclosure, then what is the point? Now, if you will see in most member states' laws, I haven't related all of them here, there is nevertheless a clause in relation to fraudulent intention or fraudulent disclosure. So I'm going to come back to that again and again. The so-called, I call it the get out clause in the treaty. How do we hook non-disclosure to fraud? Brazil has laws as well because it has specific ABS laws. And basically, if there is you know, if there is a grant of IP in relation to GR and TK, and it was done in non-compliance with the law, and that law basically requires consent and a proof of the consent, either through a certificate or a contract. If you get rights without going through those ABS provisions, you basically get a fine. The fines are not a lot. I mean, 1,000, I calculated it to 2 days ago. It's between 1,600 and 32,000 US dollars in relation to IP rights and non-enforcement within Brazilian sovereignty. And you can see, although national laws may have disclosures, they vary. Remember, but a lot of laws vary in many provisions and many implementations of TRIPS or CBDs. But it is relying on two things. One, the national member state already has something in relation to CBD. So if a country is going to implement the 2024 WIPO treaty, in absence of a national law on access and benefit sharing, you do need that linkage, that linkage I told you about, the Doha Ministerial Declaration making a linkage between TRIPS and CBD, because it could be the national law does not have any CBD provisions at all. And a lot of these countries that do have CBD provisions tend to be origin countries. Sorry. Oh, sorry, I missed one. So China, for example, does have has incorporated its sort of CBD language into its patent law. And basically no patent is going to be given for inventions which use genetic resources. Now, interestingly enough, China only talks about genetic resources and not about traditional knowledge. But if you're going to use genetic resources from the jurisdiction, no patent right is going to be granted unless you have disclosure. In patent applicants have to indicate direct and original source of the resources, but they are given the opportunity to state reasons why it is impossible to state the original source. And I need to find out whether that means that a patent applicant can just basically state that they knew about the resource due to a publication, and then they found the resource in a research or seed bank situated in another country, and most likely it will mean it. The language is also interesting as to what the disclosure encapsulates, which is any material taken from human, animal, plant, organisms containing genetically functioning units with actual or potential value, and that language comes from CBD as well. This is something that you do find in every country, which has a different definition of genetic resources, but that is to be expected. Other countries included Burundi, and Burundi, Costa Rica, and Cuba are all quite interesting in terms of consequences. So in Burundi, if there is a failure of disclosure, the competent authority can claim ownership of the application, which I found quite interesting. But if you do look at Annex 1 or Annex A of the Nagoya Protocol, some of the guidelines it does include, it introduces and includes the notion of joint ownership between the sovereign state or the indigenous persons and communities and the patent applicant. So I suppose Burundi just goes one step further and says, well, it doesn't really matter about the indigenous persons and local peoples, because the state's going to claim the joint ownership. Costa Rica, in terms of consequences, basically states that you have to have the certificate of origin issued by the technical office in conjunction with the National Seed Office and the IP registers. So this is a country that sort of incorporates the fact that the discussion has been going across different platforms, CBD, TRIPS, WIPO, bond guidelines, and incorporates that into its law to say, well, in order to get this decision done, you need these consultations with the three offices, presumably dealing with 3 different areas within the country. In some ways, it kind of makes sense, because if you have a national authority that deals with databases and knows the sort of genetic resources, seeds and plants that exist in situ in one's country, and if you have the National Patent Office that deals only with patent applications without the accompanying knowledge of what the genetic resources within one's country is, or about the traditional knowledge, but has access to the search, capabilities across the world for patent information, and a technical office that is dealing with prior informed consent and perhaps dealing with indigenous peoples and land claims, etc. It sort of makes sense for the sovereign office, sovereign country, sorry, to combine the resources and knowledges of its own national authorities when it comes to this disclosure provision. Partly because, unlike normal patent disclosures, as the sufficiency in the disclosure about the workings of the invention for the reasonable person, this one takes into account different treaties. And when you look at the preamble of the 2024 treaty, it does acknowledge that has to be mutually supportive of other treaties. And there is an acknowledgement of the UN Declaration on the Rights of Indigenous Persons. There is an acknowledgement, if you look in all the different diplomatic language in the 2024 treaty, that it is one part of a bigger international regime rather than just patent law. So the Costa Rica approach seems quite reasonable, where you also pull the resources of your national authorities. Cuba basically says it's a mandatory disclosure, and I need to check this one and ask some Cuban lawyers, because the law as it stands says it doesn't affect the examination and processing and other validity of the rights. And so in which case, Cuban law suggests that it looks like the EU version, where it looks mandatory, but in terms of consequences, there are none. Then it becomes just a suggestion. So these are the sort of the countries I've been looking into. I've just basically very vaguely put them into boxes in terms of geographic regions. There's more in this lot, which is widely, I've just put it as European and Eurasian, but that it is quite a few countries which talk about genetic resources. Not all countries, of course, have the second part and related or associated TK. But in terms of genetic resources, countries seem to be quite keen to know where their local resources are ending up in. So we come to the actual treaty itself. Beres, how long do I have? I'm not keeping a time.
You've just gone through 40 minutes, but I think we're all wrapped in attention here and waiting for part 3, so please do carry on.
Yeah, okay. Yeah. So this is the treaty. We know the treaty. These are pictures so that it amuses you in the morning. That's me at the back on the top left. I hope I look as if I'm reading something really important. Now this was in relation to the IGC. Before that was the ad hoc committee of experts meeting and an IGC, and we met many people, and a lot of you will know the gentleman in the middle, which is Chidi, who was the voice of the African group, and Christoph, who used to be in UNCTAD and now Swiss Patent Office. So It was very interesting, as I said. Geneva was awfully cold in February. It was awfully cold. It was horrible, the wind. But in terms of sitting inside, it was very interesting. To see who supported it, who remained silent is just as interesting as well. And of course, who supported the US and the EU. I have to say, I wasn't impressed with some of the European Union countries, member states, as well as the EU as a whole, and neither was I impressed with the United States because it was such old objections without coming out with anything constructive. And I think there was a feeling that this treaty will go through. Um, but and it did in the end, partly due to the WIPO Secretariat. So I know Barry said I sat in the ad hoc committee of experts during this thing, but the Director General Ben Venlin also had a smaller group of peoples, of which I was one of a group, who he could consult throughout the whole diplomatic conference when particular issues arose. My part was tiny. I just kept on looking at and checking the Vienna Convention on laws and treaties in terms of, whether or not there was a conflict with other international treaties and precedents and language. But the fact that the WIPO Secretariat actually, and they kindly paid us as well, they had a tiny group following the Director General if something came out and at any point. And I know those who attended the conference said it was so well organized, of course, by the Brazilian ambassador in terms of diplomacy and in terms of workable language, in terms of all the huddling that they apparently did outside committee rooms and outside the plenary hall, that there was so much impetus for it to actually go through, and it was going to go through. And of course, from the draft language, and if anyone's interested in many draft languages, but this is the Ian Goss draft, which sort of startled a lot of observers because it was slapped on to say, look, we're going to go on with it. And in terms, and my co-author Graham Dudfield is a better one in terms of history and people involved on getting things off the ground, because treaties just don't appear because we all have some sort of goodwill to make the world good and introduce new international norms. And Ian Goss was very instrumental in getting it. The language of his original draft goes on with the preamble of in the treaties, i.e., that we're not going to do anything new. This was really an assurance in the United States and the European Union and Japan and other such developed countries, including Switzerland, that and no one should be disappointed about it. I do get sometimes annoyed when commentators are very critical of treaties. A lot of commentators are critical of Nagoya, and yeah, there's such wonderful stuff in that Annex 1 of the Nagoya, honestly. And critical about this, it didn't go far enough. It can never go far enough because that's just going against politics and the nature of negotiations and diplomacy. And they had to use this language that is not going to change anything. We're not going to talk about, and that's very clear, about ABS and misappropriation of TK, because that is in the other platforms are dealing with it is in there. We're not going to talk about anything other than enhanced efficacy and transparency and quality of the patent system. And those words, especially transparency and quality of the patent system, was very much repeated almost ad nauseum throughout the conference and throughout discussions of it and in the summary statements by WIPO after the treaty. And it's very much part of the push, the soft diplomatic push, that we're just thinking you need to have it there because it makes your patent system a stronger patent system. And indeed, Dan Tang, when he opened the whole DIPCON, spoke about how the treaty was strengthening the patent system as opposed to weakening it, and disclosure is part and parcel of it. And I think that we should incorporate that very much when we look at how we implement it. So the preamble has all this language, and you can find it inside there. Yeah. And of course, just to say what I've been getting to, the treaty doesn't do anything about misappropriation. It doesn't talk about what the CBD talks about, i.e. the utilization of the genetic resources without compliance with national ABS laws or national laws on TK. There's no obligation to check. What I find difficult to take into heart is the third part. There's no duty of diligence. And I believe, and I would say that member states have a flexibility to add the duty of disclosure with a check on the duty of diligence, i.e. that there should be due diligence when you make that declaration that this patent application is true and correct to the best of our knowledge. Partly because WIPO gives a get out clause in the language. If you recall, what Article 3 says is member states are invited, to give guidelines as to how to fulfill the disclosure or disclosure requirement. In which case, I think it's quite well within member states' rights to say, and the disclosure requirement is fulfilled. And if you sign this declaration saying it's true and correct, then you also swear that you have done a due diligence search. So it does state all this, and I'm going to talk about fraudulence now. So it's the failure, if the failure to disclose is a product of fraudulent intent, then you can have far more heavy sanctions, including revocation. But you can't revoke or invalidate based solely on the ground of failure to disclose. So my suggestion for that whole paper is, does failure to disclose, can we make it equivalent to fraudulent intent? And I think the only way you can equate it to fraudulent intent is to also tie it to due diligence. And if you cannot show due diligence search, then it is presumption, it is presumed that there may be some fraud. And in a lot of EU member states laws, by the way, and like I said, I haven't done every world's laws, patent laws, there is invalidation or revocation if fraud is shown. So it's very unclear what fraud is. So I come to the last part, which is how do you implement it? This basically is just a roundup. Part 4, and I'm going to end with part 4, which is, I think at some point one has to ask, why do we have a disclosure requirement? And a lot of the literature says it's about the CBD, it's about ABS, it's about the rights of traditional peoples and indigenous communities, etc. But I would say, is there a wider holistic, pluralistic, and wider justification why there is a disclosure requirement in patent law, putting all the other platforms and all the other treaties aside, and also giving something to national courts to hold on to when there is a challenge based on non-disclosure. And basically I'd say, yeah. What is the trigger for the provision depends on the rationale. So when you challenge the non-disclosure, or when another country, let's say my example, Mauritania, which is the country of origin, or it's a country where the indigenous group is situated with the traditional knowledge, challenges it, at some point a national court where the patent has been granted has to say, well, what is the rationale for justification for disclosure? In one sense, you can go back to old-fashioned patent law and say, well, it is to show that it's inventive and it's novel. And when Graham and I gave a version of this paper at the Oxford IP Institute, I think there was 1 or 2 patent attorneys in the audience who said, well, this just basically goes to patent law. I mean, it's nothing new. I mean, if there's non-disclosure, or whether you disclose, does go into engaging the novelty and inventiveness of the invention. So that is one way to look at it. It's just part and parcel, and this treaty doesn't do anything much. But that is what the treaty also says. It's about the transparency of ordinary, normal patent norms. Is the invention valid? Is the person applying for it entitled, is the company entitled to own that intellectual property? However, I would say there are more justifications for the disclosure requirement in the 2024 treaty. Partly because the origin requirements do assist in tracking exploitation of GRTK, and that is part and parcel of it. So in one sense, patent law gives a court and gives the national implementing country a reason why you have to have this new disclosure requirement, which you basically extend to GRTKs, because it's part of the patent system, which is in public interest, it's economic welfare, it helps transfer tech, efficiency. That is part and parcel of normal patent law. And the 2024 treaty doesn't necessarily add to it. However, I do think it does add to the notion of equity and fairness and CBD. The disclosure in relation to GRTK is about implementing the CBD access and benefit sharing regime, is about in violation of this particular convention from an equitable and fair perspective. And why do I go on about it in my work on equity and fairness? Is because then if you look at Nagoya Protocol as well, it does talk about promotion, encouragement of access and technology. And one way to do it is the disclosure provision, because then at least the origin countries or the origin groups and communities would know that their knowledge or resource has been used somewhere else, and it's been used and reformed into something else, and that technology should be shared, which is part and parcel of patent law and research and development. But most importantly, and this is to keep on saying, it is about diversity, it is about ownership, etc. But most importantly, if you actually look at the preamble is wide enough to incorporate lots of rationales for disclosure. Of course, I kept telling you, one of the things promoted by the WIPO Secretariat and the Director General, this treaty doesn't do anything new. It is all about consistency and legal certainty and transparency. And that is, what a rule of law should do anyway. It is also about equity in the sense that there is no erroneous granting of patent law, and there's no erroneous granting, not patent law, sorry, of patents to inventions which don't fulfill normal requirements of patent law. However, it does acknowledge the UN DRIP. It acknowledges that indigenous peoples and communities should be involved in implementing this treaty, which is a sort of a nod towards the fact that, yes, it needs to be a bit wider than what we have now in patent law. And we recognize all the other treaties. And more importantly, I think to go back to what I started in the first few slides about the ministerial declaration in KL, paragraph 19, which says there is a link between TRIPS and the CBD. There is a link between ABS and the TRIPS agreement, i.e. patent law provisions, and that link should be considered in light of Article 7 and 8 of the TRIPS agreement. And you all know what Article 7 and 8 is. It's that wonderful big welfare. We need to look at national health. We need to look at the socioeconomic industries and areas of importance in countries. And it is that welfare enhancing provisions of the TRIPS agreement. And it includes development and technological objectives as well. One last thing, and I'll only spend 2 minutes on it, because most people know about the United States, Bayh-Dole's provision, and I'm very grateful to my colleague, Duncan Matthews, for pointing out Jamie Love's observations while we were watching the, during the diplomatic process, and also in the IGC, he was commenting on his blogs and in the KEI website that there should be better enforcement mechanisms in the treaty. As I said, the original versions had far more emphatic enforcements, i.e. non-disclosure can lead to ABC, Whereas this version has non-disclosure. Well, you can't invalidate just because of non-disclosure. They have to have a chance to rectify, and national courts can do certain things. And he was arguing that it has to be strengthened. And the reason he was arguing it has to be strengthened is because of the United States experience on the Bayh-Dole. And there is a very fascinating article, which, you know, if you want, you should get hold of. I think it's available on Hein online, or on the internet, a 2024 piece between him and sorry, I just forgot. I think it's Cassandra Cassidy, but yeah, I just forgot the first name of his co-author. In relation to Article 6, the disclosure provision, but they basically do a whole analysis on what's happened under the United States Bayh-Dole Act. Basically, the provisions of the U.S. federal regulation is that there has to be a disclosure. So that's basically the only sort of, you know, similarity between the 2024 treaty and the Bayh-Dole discussion. But the disclosure is connected to when a company receives governmental funding. And if you receive federal funding, you have to disclose it in relation to the invention, the contractual requirements for the disclosure, etc. And in their analysis, where they do several companies, they're basically, and there's been 2 reports, there's a view coming from, you know, this 2024 paper, that there has been very little disclosure because the enforcement of the disclosure obligation is very weak. And once that enforcement, you know, the penalties and sanctions as set out in Article 5 of the 2024 WIPO treaty, shows that it is quite weak, then you're not going to have disclosure. These are several examples only of the ones listed in the 2024 paper. There's tons of different examples. A lot of it was gained by KEIs asking for information disclosures from different government, different federal funding institutions. And they say that they can only see one real instance where it goes to court, which is the first case where the U.S. government takes the title because there was funding from the U.S. Army. But they said that was one instance they found that the U.S. Army actually went to look for inventions and patented inventions which got funding. In their view, a lot of the other funding bodies in the United States don't take any action, or they persuade the company or the university to file a correction of it. I was very surprised, and I need to go and figure out what's been happening. But there is apparently a look at Moderna and Novartis as to the fact that they have failed to disclose any government funding. And so the whole point of that whole discussion in Bayh-Dole, I thought was quite effective to show us what's going to happen if you do implement the 2024 treaty without any sanctions. You know, you basically go and persuade the patentee, come on, chaps, you know, change it and just put some disclosure. You can put secondary disclosures, as secondary provenances, for example, you got it from an article, etc. And I believe that the fact that it talks about fraud, and look at the case of Novartis, which I highlighted in blue. If you haven't disclosed it after 18 years, and then you do disclose it, which shows that you must have known there was some disclosure to disclose. And in this case, in the case of the Bayh-Dole Act, it's quite clear, did you get funding from a federal authority or not? So it's a lot more clear-cut, I admit, than the 2024 treaty in terms of disclosure. But in many cases, I do believe that the research and development departments do know when genetic resources and knowledge are coming from different geographic origins, partly because of how it's revealed in publications, how it's revealed in scientific work, and how it's revealed in, I mean, so we're not even talking about in situ country of origin, we're talking about secondary sources and how it is placed in research databases. There will always be exceptions. I know this. I've read the applications of a lot of patent agents in relation to wheat, for example, and rice varieties, where it's very hard to trace. And there are cases where it's very hard to trace. But what the treaty is saying is there should be some disclosure, rather than no disclosure whatsoever. So that is the treaty, just to remind you again, where it says member states can give guidance as to how to meet the disclosure requirements. And one of the things is the disclosure requirements should not just have images, because as you see from above in the last sentence about the Bayh-Dole, when the disclosures are laid, according to the 2024 paper by them, when the disclosures are laid, the people checking for federal funding cannot see disclosures because they're only available as image files rather than text. And therefore, there are various ways in which you can tinker with 3.4 as to how you're going to meet it. Also, I think you should link it with due process. And also 3.3 has a lot of flexibility. So this is the last slide. So basically my personal view is Article 3 and 3.4 are vital for lobbying groups, you know, and member states to take advantage to such an extent that the burden of proof is also on the applicant to say, you know, I'm signing the certificate and I have done a due process search. This applies in other law, and the quickest thing I could think about was the EU copyright law, which requires declaration that they are orphan works if you have done the due process search. And the second thing is, and this one I'm thinking about it, I don't know, you can say that's wrong, how to equate, or that one should equate non-disclosure because there was no due process, because of a lack of search, to fraudulent intent. Because once you have fraudulent intent, you trigger the invalidation. And it's basically, like I said, to counter the Bayh-Dole effect, where what's the point of a disclosure without a sanction? Okay, Boris, I think I did it in that hour.
I think you did. That was amazing. Thank you so much, Professor Suthersanen. If everyone wants to join me in a round of applause and virtual reactions, that was fantastic. Thank you so much. What a tour of the relative sticks and carrots entertained by the treaty. We've got a couple of questions just ready to go. One from my colleague Tolu, who isn't able to come on the mic at the moment. And one from myself, one for clarification and one out of curiosity, I guess. So the clarificatory question.
Oh, sorry, I just want to say thank you, Manu. It's Malawi. Okay, I thought it was Namibia. Well done, Malawi. Malawi became the first one to ratify it. Thank you.
Indeed. Well done, Malawi. Yes, so the questions both relate to genetic resources and the definition. So the first is, how do you see the extension to digital sequence information occurring? Is that something that the vagueness of genetic resources as conceptualized in this treaty and many others will allow more easily and readily?
You see how assiduously I was trying to avoid the word genetic sequence information, DSI. All right, so Article 6 of their treaty encourages member states to have databases of genetic resources in TK. And it is in the discussions that came out, if you have such databases and information systems, you would also include, if you can and if you wish to, you know, digital sequencing information about this. It was controversial, of course, about whether or not the language should include DSI, etc. And so the compromise article, I remember we were asked many times to check the language. Article 8. And Article 8 is lovely because Article 8 of the treaty says the contracting parties commit to a review of the scope and contents of the treaty, addressing issues such as the possible extension of the disclosure requirement to other areas of intellectual property and to derivatives, so that's A, and addressing other issues arising from new and emerging technologies that are relevant for the treaty. So that's where the DSI was sort of collapsed into, if you think of it, Article 8, the review provision is a black hole, and it collapsed into that black hole, saying, okay, and that was, like you said, a carrot saying we can review it. If you think that the DSI is going to get to such an extent, then you can review it. So the only other thing right now would be to go back to, I didn't go into definitions, but genetic resources are genetic material of actual and potential value, which is what, for example, China has in its provision. Genetic material means any material, plant, animal, microbial, or other origin containing functional units of heredity. There is nothing here that basically says it cannot be held in information sequencing. Because I'll come back to that. I forgot to say also, if you look at the definitions of source of genetic resources, the treaty does say, remember I was talking about primary sources when it's in situ, and then secondary sources. It acknowledges it in the definition and the footnotes of Article 2, the definitional article of the treaty, that it includes genetic resources such as research center, gene bank, indigenous communities, multilateral system of the Treaty on Plant Genetic Resources within Agriculture, and any other ex-situ collection or depository of genetic resources, including scientific literature, accessible databases, etc. Basically, it is arguable for a country to include DSI, I would say. The treaty just did not want to touch it because it's just far, far too controversial. With the United States saying we can't, have that sort of language if we don't have something strong about. Basically, the US's view was, okay, we're quite happy to comply, but we don't want to have claimants coming to the USPTO stating that this can't be included because it's part of our, DSI. And the first thing is we go, well, where's the evidence? So the US's version was we're happy to go along with it, but in countries holding resources have to take some of the responsibility to having their own national collections available for purposes of verification. And therefore, I believe if countries are very concerned about it, then it is one thing to have the database. I did discuss with Graham, but it is sort of like catch-22. So on the one hand, if you want to implement CBD, it assumes that there is a pattern. It assumes a successful pattern because you want the benefits. That's the whole point, is the access to and benefits. So one benefit, of course, tech transfer, and the other benefit is monetary benefits. But you will destroy the monetary benefits angle because you will destroy novelty, and therefore there will be no patents. So it's about which ground you want to go for, because by publishing it in databases, your intention is firmly to say there should be no patents because the novelty is, well, there has to be more done by the patent applicant to show that this is a derivative. But if you look at that language, I mean, that's where it's all collapsed into the language of Article 8. The words derivatives and the words new and emerging technologies were carefully chosen in order to include digital sequencing information, and to say we're not dealing with it now, open for review. Sorry, was that the question?
That was, and Charles has also picked up on this issue of definitions. Charles, are you there? Do you want to turn your microphone on and say hello and put these thoughts yourself? He's coming.
Oh, hello everybody.
Charles.
Thank you. That was terrific. I guess the politics here is that we have these uncertain terms, and if everyone agrees that we can just use that term, then you can negotiate outcomes. But there are key terms here like genetic resources in the WIPO agreement doesn't really deal with the derivative problem that the Nagoya Protocol had, and I guess the political fix in the Nagoya Protocol dealing with utilization and all the derivatives of genetic resources. But I guess when you're talking about patents, I mean, patents have moved on from gene sequences. Many jurisdictions, they're not patentable now. We're talking about a whole lot of artificial kinds of chemicals, and a whole artificial biological kind of materials, so things like artificial proteins, all those sorts of things. The question then comes is, what do you mean by based on? Based on becomes a really critical term here. I appreciate it is defined in there, but it doesn't really help, whether it's directly based on or indirectly based on, those sort of things. So I guess I hear the process. I have no problem with the idea of the process, but it really comes down to understanding exactly what some of these terms mean. When you were saying that you're a lawyer, a black letter lawyer, then clearly, terms have to mean things. We have to understand and have a mutual understanding what they are. But terms like traditional knowledge, they mean different things in different places. So, for example, in Queensland, traditional knowledge is what an Indigenous person says it is. If they say it's the tree, then that's the tree. That's the traditional knowledge. It can be all sorts of things. It depends on the cosmology of the person you're speaking to. So, I guess we need to. I'd be interested in any thoughts you have about how we go about actually trying to work out the dimensions of what these words are. Thank you.
I completely agree with you, and they were left vague precisely for the reasons that you alluded to. Diplomatically, it held up the whole process for a long time to get to a definition, and therefore, I think WIPO and a lot of countries agreed that what we want is a treaty on the disclosure. So basically you have to give up certain things, and there is no agreement on what traditional knowledge is. Therefore, should there be an international norm on what traditional knowledge is when there can be so little agreement on it? And the same with genetic resources. So there is language already in CBD, which some countries have incorporated. But again, I think they really wanted to be around the language issue to get to the more procedural rule, which is disclosure. I completely agree. And I think the reason I say I was a black letter lawyer is black letter lawyers also know that we need the flexibilities. There is a lot of flexibilities in the law, and it will depend, therefore, on member states to implement. For example, we have no idea what novel means or inventive step, and it really depends on different regions to come up with the notion of novelty. We still don't know what patentable subject matter is. Well, when I teach US patent law to my students, I always acknowledge, now, first of all, understand that I come from a common law and EU position. I cannot understand how Americans get along with patent law, which has no excluded subject matter, because I'm so used to statutory excluded subject matter, that it's beyond me to figure out how they go about a law that doesn't define the subject matter in terms of excluded subject matter. So I think, it's never going to be defined. It really is up to member states. And I read 2 or 3 papers, and it was really interesting, from that Brad Sherman kindly sent to me. And I also understand that there is no definition sometimes in terms of natural jurisdictions. So Queensland may have laws, but other Australian states, I understand, do not have laws. And there is, and correct me if I'm wrong, there is no general federal ABS law in the whole of Australia. And therefore, maybe that's the flexibility level. I hope that answers you, Charles.
I might jump in if that's okay, because my question was coming from exactly the opposite direction. So I had a little joyful moment when you talked about the openness of law and the necessary function of this. And I had another little joyful moment when you insisted that you were not going to unvagify genetic resources. So I wanted to bring that moment together with the subtitle of your talk, which is the construction of guidelines for ADS. And guidelines are often represented as definitive moments in which definitions are laid out, terms are reified and solidified. Does this mean that there might be a productive avenue to explore here in terms of thinking more iteratively and in more processual ways about guidelines maybe even thinking of them as case-by-case discussions, which are ongoing, as iterative projects rather than definitive ones.
You mean a set of a code that is constantly redrawn according to every challenge that comes about it? But again, this is you're basically stating how common law works, where it constantly redraws boundaries and guidelines according to each each case as and you get to a tort. I mean, you know the first thing, and everyone here will know, the first thing we do in law school is to follow something, and in a lot of common law jurisdictions you follow the law of negligence, which starts from the snail in the ginger beer can right up to a full-blown, fully fledged tort of negligence. And it is, as you stated, it's and therefore I think the only way this treaty went through was to remain as vague as it did and not to give the definitions. And for all of us who have been following the different versions of the treaties throughout the IGCs, I think, is it for over 20 years? Oh, that must be what, about 10 different definitions, 12 of what is TK and what is TCE and what is traditional, etc. And no one's going to agree on it. None of us agree. I mean, look at the Berne Convention and Paris Convention, done so long ago by our wonderful, imperial masters, and we thank them for that. But in the 19th century, there were 5 countries, and they all agreed, let's protect this stuff, and we'll just call it literary and scientific works. And you can include, and then they put a whole lot of stuff in there, and it's a bit that way. I don't think strict definitions going to help anything from now on. Everyone has their own view. So yeah, I like the word. I'm going to use it in the article. Iterative process. Thank you, Barry.
Well, hopefully we can look forward to you coming back next year to give us the lowdown on the 2025 WIPO Treaty on Genetic Resources and Traditional Knowledge, the next iteration. And maybe
or the
subsequent
TCEs.
years.
Yes. But I'm so pleased with some of the person on the chat boxes, and thank you, Manu, for that as well. I haven't been following the IGCs in the last year or so. Please do email me if there's something you disagree with. I'm still not 100% convinced about how to do it, so I'll only know when I try and draft it, because I'm hoping to draft some small little thing, but I'll only know when I check how the Swiss provisions work. I understand in the US patent law, one has to make a declaration or an oath that one has actually invented the invention, or is a true inventor of the invention. There is a moral right as well provision in the European Patent Convention about stating that one is the inventor, acknowledging inventors, and that is connected to the disclosure. Because if you're not the actual originator of the knowledge, let's say, one should actually state it in your prior art specs. So, yeah.
Okay, I think it's time for a final call for questions. There's a comment here from
yes, I
Harari.
am, my too. Sorry. Yeah, we were following quite a lot with the Pacific countries looking at that. And if I'm not mistaken, also, there was one country, yeah, but we were looking forward to that as well, the Pacific Island countries ratifying the treaties.
Okay.
Is it Fiji?
If there's any final comment you would like to make, Professor Suthersanen? Oh, and there's a hand raised from Claudio Chiarola. If you want to come on the microphone and ask a question, that would be fantastic.
Yes, good morning, good evening, good time of the day to all of you, and thanks, Suma, for the great presentation on the WIPO treaty.
Hi, Claudio. I read your work
Great to
with
see you.
Burju on this. I really appreciated that work you did with Burju on this, the whole disclosure thing.
Great, thanks so much. So my question is, with respect to the issue that the WIPO treaty, sets some maximum standards as well, with respect to certain issues, as you said, for example, in terms of being able to take some measures to sanction no violation of by patent applicants, if they disclose false information and so on. And so what is your appreciation, for example, in terms of the advantage that countries that already have patent disclosure requirements in their national legislation or might have to actually ratify? Because sometimes they provide already for sanctions that go beyond what probably is allowed under the treaty. So perhaps they would even have to modify their legislation, lower what is already provided therein, which could be, counterproductive if I follow your reasoning now, saying we need to have some grips for this to actually work.
Okay. Thank you.
Yeah, thanks.
Yeah, that was a good question because I didn't clarify. So for those countries that do not have any disclosure provisions, if they introduce a disclosure provision according to the treaty, they should link it to the fraudulence. Now, in terms of what Claudia says quite rightly, that there are certain, ceilings put by Article 5. And Article 5, basically, I'm just rechecking, looking at it. You cannot invalidate, revoke the patent right solely on the basis of failure to disclose. So that's the ceiling. But it does allow you for the revocation where there's fraud. So that I was just advocating, how do you connect, and one should connect failure to disclose without doing due diligence to fraud. Because that's for those without it. And what you're saying is for those countries who already have their disclosure provisions, right? And who already have, far bigger, where you can have revocation on non-disclosure, for example. And not many people are listening to this, right? So the first one I would say is don't do anything. Until someone comes out and points out to you, by the way, you haven't implemented it according to the treaty. I've seen how I hate to say it, but I've seen how WIPO and UNCTAD work sometimes in some countries. It sort of depends on how much persuasive force they have on the country's authorities, and how much no persuasive force they have on countries like China, which goes like, this is what we're gonna do. So don't do anything, or else if one wants to really be correct, I believe then you should implement, change the disclosure provision to state in relation to inventions which incorporate GR and TK, the mere fact of non-disclosure will not lead to invalidation. I think then, you know what, right? Because, I knew Claudia from long ago when he was a small boy doing his PhD at Queen Mary. But you've been working in this area for ages. They always talk about flexibilities. And then there's, and flexibility should mean that the country's own national policy provisions should dictate how you sway your disclosure provision. So if you're an origin country who's, really wishes to make clear our view is a failure of disclosure means you shouldn't get right, I think you should veer towards a stricter one. However, if you're a EU member state, let's say that doesn't want to invalidate patents just because of a failure to disclose, then I think Article 5.3 is a boom to you, because it basically says failure to disclose doesn't mean invalidation, and you can enlarge it to mean any failure to disclose, rather like how they do it in practice in the United States for the Bayh-Dole. Failure to disclose basically means the patent office who's informed that person, that applicant failed to disclose, patent office goes, okay, let's call them up and persuade them over the phone to put some reference in. You give them chance after chance to rectify it. So I think it depends on countries' policies and that flexibility.
Thanks so much, Uma. And great to see you and looking forward to reading the paper as well.
We'll send it to you for comments.
Thank you. That would be
Thank you.
lovely.
So lovely to see you, Claudia. Paris.
Well, I'm keen to see if anyone else has a question which comes out, but I'm also aware that you've now done the longest Q&A session from any of our
Sorry.
talks.
I think the paper is a
Absolutely.
bit too long. But I'm
No,
aware
it was
that
perfect.
the Europeans need breakfast soon.
Well, I think a measure of the paper is the discussion that it's kicked off afterwards. Is
Yeah,
that
but
oh, sorry.
please, I would really be grateful if people pointed out where I've gone wrong, where I've misunderstood certain nuances. But I really do have to thank Charles. I know the point Charles made. It is in the paper. I just didn't want to talk about it because it's a minefield. And anyway, it's a rabbit hole, I think. For me. For others, of course. Whose livelihoods depend on defining.
Well, yeah, I think that
Look,
that
we all
issue of
know
ambiguity
it's
versus precision.
it's going to be an issue, and I don't think solving it helps, because no matter how much you solve it, then the discussions in court will be about exactly what the words mean. So yes, sometimes we love the exact words, but sometimes we don't want it because we want that flexibility to argue in court. And I know that stakeholders, especially industrial stakeholders, prefer everything to be done legislatively because they don't trust judges to go with the view that they wish. I always prefer a judge's view, although they might get it completely wrong, but then you have the chance of the next court getting it right. So it's about betting, hedging your bets.
Can I ask another question, or maybe make a comment?
Sure.
The reason this is important is because even when the CBD was negotiated, there was always a problem with user obligations.
Sorry, I didn't get the last.
Tried to protocol and that.
I'm sorry, Charles, your connection's really poor. We missed all of that last paragraph of 4. If you could just rephrase it for us, please.
Okay. I shall pass. Thank you.
Sorry, did I get it, Barris? Is it my connection?
I think it's Charles's connection, because I was struggling to hear you as well, Charles.
But I don't know whether Charles can hear us. He's frozen.
Let's
So
hope so. And yes, go for it.
But I just want to say, in response to Charles, and if you could relate it to him, I also have read his paper. I just wanted to recheck when it was from, and I have read the paper by Charles Lawson's friend Humphreys, Michelle Rook in GIPLIP 2024 about the DSI and the genetic thing, and I do agree with them as to what it means. And that DSI is not a clear object. I appreciate that proponents want clarity, but in terms of technology, I do know, with my copyright hat on, that the law is always 2 steps behind the technology. It always is. So when you try to put things in a far more clearer term, especially what genetic resources and information is, it's bound to be a bit old. But I do appreciate all the points they brought out in that 2024. And by the way, for anyone who needs to read it, it's in GIPLIP, the Journal of IP Law and Practice, 2024.
It's a fantastic paper, yeah. So
It
Charles
is.
will be able to hear your response on the recording when we listen back. If there's anything
No,
else you
no.
wanted to say just on that.
No, I would say that anything to read about the problems of DSI within the entire ABS discussion is very nicely put out in this paper. But we're talking about intellectual property, and maybe I'm doing too much IP lawyer as well. We all know intellectual property is supposed to be about intangible information. We know it's about information. We know that we do the fictions in order to protect the information, which we're not supposed to say we're protecting in a manifestation of the information in a product or a process or in a book or something. But there are two lines, the physical, the genetic resources, but within it, as an IP lawyer, you know there's always that information is being protected in its raw form as information. I also think there's a view that it's not raw information and it shouldn't extend. And I if I'm not mistaken, someone can tell me I'm wrong. It came up when you look at the Court of Appeal in the Myriad decision, where it was really interesting, according to the backgrounds of the different circuit judges, whether or not, they were chemists, how a chemist views information, how a business, management person views information, how an engineer views information. I'm well aware that different sectors, different professions view it as different things, whether it's chemical or physical or, databases of sequences. Speaking on behalf of lawmakers, because I like lawmakers, I think they have a difficult job. The law cannot incorporate and accommodate to so many views. And this one, as if anyone who's read my co-author Graham Dudfield's works on TK and TCE, keeps on saying, honestly, the law can't do it without anthropology, without sciences, without history, etc., etc. So we can't do the definitions. I hope everyone's upbeat about that.
It's just so fantastic to hang out with you. And there is
Thank
one
you,
more comment
Iris.
in the chat box.
Oh,
If we
sorry, I didn't see.
give you one more, this one's from Tolu, and what he's pointing to is that the move to DSI means that you no longer need physical access. And so any frameworks which rely on physical access will tend to break down as we go to the digital sequence information.
And Tolu is talking about about ABS frameworks as emanating from CBT, right?
Mm-hmm.
Yeah, which I think is the Lawson, one of the things brought up by the Lawson et al.'s paper, Humphreys and Rowe's paper. Part two. I really did not want to look at DSI because I know it's so controversial. Everyone I talk to has different views on it. And those people who are actually on the ground working with it since, like I said, I'm coming from it from a very new angle. I'm just a newbie here. There are people who worked in this area for 30, 40 years since, the CBD negotiations. They have very the far bigger views on this. They know what's happening. I really wanted to focus on just what a lawyer coming to a treaty looks at. So the next one is about DSI. I
think that's a nice way to divide the labor.
But do you know, Paris, when there's some areas you look at and there's, I used to in my youth PhD work in the area of designs and works of applied art, and one of the areas I just really didn't want to look at for a very long time was trademarks and trademark protection or shit, because you go like, I know there's a problem there. I know it's bubbling. I know it's boiling, but really it's going to destroy my vision on two other areas of IP law if I look even closely there. And that's the sort of feeling I have about DSI.
I think, yeah, that's pointing to something quite substantive, right? And that the small marginal cases can often come to dominate what's happening in the mainstream. And of course, the people who say that DSI is important would say that it's never going to be small or marginal, and it will dominate what's happening around genetic resources, because all genetic resources will go DSI eventually. But perhaps
will
something
go
quite different
DSI.
will happen.
And I do think the reason I'm reluctant to look at it as well is because I do think we need to look at other areas like database laws and regulation of just pure data information, and the concept of data, which is starting in the European Union, in German law and UK law as well, had law reform, as to whether or not we're going to look at a pure data object as property. And this is not about IP law. It's almost like redoing the law of real property, you know, adding a new category in, which is huge. And they've done it in German law as well. So it's not just going to be about IP when it comes to things like DSI. It is about the whole area of property. So it's not like it's a small issue. It's like if we get bogged down by it, we're never going to get anywhere.
That's fascinating. So it might be big enough to overrun us, or it might dominate us.
Because of the discussions right now on whether or not we relook at the notion of property per se rather than IP, because IP has all these rules which property is not hindered by.
There is another question, and it is about DSI again.
And no, Jasmine, AI generated sequences. I think then you go back to patent law, and you have all these countries who put their firm foot in the ground saying, we are not giving patents to AI generated creations. There's a whole host of case law on this, and I think, yeah, including Australia. And ditto copyright law as well. And once you're talking about information, by the way, you cannot talk about patents, because you are talking about databases and copyrights and compilations. So it will spread over to IP as a whole for data, pure digital data.
Okay, I think we have taunted you on DSI for long enough now.
No, I am very glad, because now I know where to pitch the part 2. You know, it is that much of a. I have to say, Jasmine, I didn't think the AI generated would be an issue, but thank you for that one too. And I thank all your audiences for their wonderful comments.
How are you feeling? Have you exhausted the subject, do you think? Are there any more questions coming in? Should we call it a day there? Let's call it a day there, I think.
Yes, and there's me really thinking how lovely it is for all of you all in Australia. Thank you.
Well, thank you so much for not only the fantastic talk, but for staying behind and engaging such a really fantastic and wide-ranging discussion. This has been a somewhat unusual and long seminar, but I think much better for it. I think it really points in a direction that enriches the seminar as an event. So thank you so much. You've really done us a great favor.
I hope to see you soon. I hope to see you here soon.
Thank you.
Bye.
So goodbye, everybody, and goodbye from the Plants, People and the Law lecture series for a year. And what a finale. I hope you'll join me in a virtual round of applause for Professor Suthersanen.
Yeah, thank you, Tolu, for all the
Thank
suggestions.
you so much.